Hi, y'all. I'm Lawyer Lee, and welcome to tonight's live stream. What is in Blake Lively's therapy notes that is so bad that she would rather drop part of her lawsuit than let Justin Baldoni see them? Tonight, we're digging into a legal showdown that is just as much about strategy and about public relations as it is about facts. Blake Lively is a well-known actress who has sued actor and producer Justin Baldoni. She says he harassed her, caused her severe emotional distress, humiliation, pain, embarrassment, all of that. Now, Justin Baldoni's lawyers are calling her on what her evidence is, and they're asking if that's true, prove it. Show us the therapy notes, show us the records. And Blake Lively's answer is absolutely not. In fact, she is so adamantly opposed to handing them over that she's ready to drop two major claims from her lawsuit altogether just to make sure those therapy records are sealed. So the question is, what is in those notes? Is it really just that she doesn't want to produce them? Or is there something more to this? What is she trying to keep private? And what does this mean for the rest of the case? So let's break it down. I'm going to give a special shout out to the first five in tonight's chat. White Mountain Witchery, Just a Girl, Real Happy, Connie Presley, and Angel LaFawn. For those of you who have missed this case thus far, Blake Lively, a well-known actress, best known for Gossip Girl and a string of popular films, Justin Baldoni directed her in a movie he also acted in. They were co-stars in this movie. It was called It Ends With Us. And ironically, it was all about domestic abuse. But now Blake says while they were on the set, while they were making this movie, Justin Baldoni used his position as director to sexually harass her. It's become a battle that is a lot more about public perception than about the legal issues. So Blake got her claims out initially in a blistering New York Times article. But then Justin Baldoni's team began pushing back, demanding access now to her therapy records. And the fight turned into a free-for-all in the public domain about privacy, about proof, and what the public thinks. So for the most part, Blake Lively has been losing that battle badly, very, very badly. All right, so let's go into, I want to go into what's happening in the case. Why does the defense think it can get Blake Lively's therapy records? I mean, what would make them think that? Because this is not a car accident case where there's a broken bone and the doctor's records might be relevant. This is not an injury case in a classic sense. Blake's lawsuit is about emotional harm. And she's saying the experience of working with Baldoni caused her intense emotional, psychological trauma. So when a plaintiff says that, makes a claim like that, then they put their mental health as part of the lawsuit. Then the courts have ruled that that has opened the door. Maybe not wide open, it's at least a crack. The other side can at least get enough information to be able to figure out whether that claim is accurate and to oppose it if they want to. So let's look at what Blake Lively is actually claiming. Let me add this to the stage. This is from the amended complaint filed by Blake Lively. It's just a list of what her claims are. I'm going to make that a little bit bigger. So let's see. There we go. Okay. So you can see she's got 15 different causes of action, which is a lot. That's really an extraordinarily large amount. They range from sexual harassment, retaliation, there's a failure to investigate, a breach of contract, false light, invasion of privacy, defamation, and civil conspiracy. And there are several counts of some of those. But there are two that I want to focus on tonight because this is where Justin Baldoni is saying he's entitled to get this. And those are the intentional infliction of emotional distress and the negligence infliction of emotional distress that she lists right there. So, and let's talk about what does that even mean? Like, what is intentional infliction of emotional distress? Well, those are serious claims that can offer significant damages, but they come with a catch, which is you have to meet all of the elements. You have to prove all the elements. So let's look at what they are in the state of California. And I've listed them out for you here. Elements of IIED, intentional infliction of emotional distress in California. And this is not legal advice, but I'm just giving you sort of my rundown of what I've seen in my research. The number one thing that a person who brings a claim like this has to prove is that there was extreme and outrageous conduct by the defendant that exceeds all bounds of decency. So extreme as to exceed all bounds of that usually tolerated in a civilized society. I mean, that's huge. That's really broad, right? That's a pretty big claim. The second thing that the person bringing the claim has to prove is that there was an intent to cause or reckless disregard of the probability of causing emotional distress. So it has to be meant. It has to be intended. So this is really extreme conduct that was intentional. Now, of course, for the negligent part of it, this would be negligent conduct, which would be a much lower threshold. Third thing to be proved, severe emotional distress suffered by the plaintiff. That would be Blake Lively. She has to show this actually caused problems for her, emotional distress for her. And then fourthly, actual and proximate causation of the emotional distress by the defendant's conduct. In other words, it's not enough to show that you had some emotional distress. You have to show the reason you had the emotional distress was what the person you're suing did. Those have to all hook up. And if they don't, then you don't win your case. So all four of these things, Blake Lively has to prove in order to prove her case. So let's pull that out of the screen and let's talk a little bit more about her case. So that's what she has to show. But the defense is saying, okay, that third part, severe emotional distress, that's really a key. You, Blake Lively, claimed that you were traumatized. Well, then you better be able to show it. So the defense is saying, are you in therapy? What are you saying about this case to your therapist? What are you saying about not so much the case after it was filed, but about the issues in the case? Like, what did you tell your therapist about how it felt to be on the set? Did you say it was great working with Justin Baldoni, or did you say that Justin Baldoni was really inappropriate and that he was harassing you? Is it consistent with what you're claiming right here in this lawsuit? Now, they want the notes because those notes, the therapy notes, the notes written out by the therapist, would be relevant to damages. If Blake Lively says she deserves compensation for emotional distress, the defense wants to verify. How severe was it? Was it caused by Baldoni? Maybe something else was going on in Blake's life that could have caused this. So this isn't really just a fishing expedition. It's actually legitimately relevant to what the claim Blake Lively is making is. So in a case like this, the court is pretty likely to say that Justin Baldoni can get some of Blake Lively's therapy records, maybe some limits on it, but very likely to say, yeah, we're going to let you have those. Blake Lively knows that, but she really doesn't want to produce these records. And here's how we found that out, that what Justin Baldoni filed with the court. Let's take a look at this letter motion that was filed with the court. This is document 262, and I'll make this a little bigger too. That might be a little too big. Let's pull this up so I can make that just a shade smaller. We'll pull that out. That might give us a little more room. Okay, so let's take a look at what they're saying, that what the Justin Baldoni side is asking for. They're saying they want an order compelling, forcing Blake Lively to identify her medical and mental health care providers. They want her to produce her mental health records and to give them, let me add that to the stage. I realize now that you are not seeing that. Okay. They want her, they also want an duly executed HIPAA authorization. Now, what's HIPAA? Well, that HIPAA authorization is what you sign when you go into the doctor's office. It's where you have the right to privacy in your medical records. And now what the Baldoni team wants is they want her to sign over that they have authorization to go get the records, maybe even to talk to her medical providers all by themselves. Now, the getting the medical records is less of a problem than the HIPAA authorization. That's always a significant issue. I personally I never let my clients sign one of those. I wanted to collect the records myself for a couple of reasons. One is that you never know when some records that are not connected to what's happening get filtered in, and you want to make sure you know that first. That's particularly going to be true for Blake Lively here, because there are records that aren't connected to her claims here, at least conceivably. And so they want to make sure. Also, the idea of the defense lawyer talking to the doctors directly is always just very nerve-wracking. So my general platform was I didn't want anybody getting those, but so what they're asking for is significant. They're asking for not just the records, but also that HIPAA authorization. So let's take a look at a little bit more at what they're asking down here at what I've labeled number 4. They said, okay, we've asked Blake Lively for these documents, and here's what we want. The names and addresses of the medical and mental health care providers that treated and or examined Miss Lively for her alleged emotional distress. Number 2, all reports and or treatment notes of those physicians and health and mental care providers who have treated and or examined Miss Lively for her alleged emotional distress. And 3, they want that HIPAA authorization. And they say it's in order to make sure we can go get the records ourselves. And it's common that there could be a battle over that. Something I've forgotten to ask, would you mind hitting the like button? It would really help the video, help the algorithm. I would really appreciate it. And if you are not yet a subscriber, we would love to have you join us. Hit that subscribe button. All right, so let's keep going. So what they're asking is not at all unreasonable. Baldoni is saying, you made your mental health a central issue. We get to see the proof. And that's true. And in fact, it makes you wonder why Blake didn't know this would happen, because yeah, that's going to happen. She put this in issue. So she doesn't say, let me go to the therapist myself. Let me get the notes. Let me redact anything inappropriate, and then I'll hand them over. And she doesn't say, these aren't even relevant. You're entitled to these. She doesn't say they don't exist. No, what she says is, okay, fine. You want those? I will drop the claims entirely. Just don't make me give you the notes. I'm not giving you the notes. So before we get into the details of what this means, let's go ahead and take a look at this, what they wrote here. That Miss Lively is withdrawing her claims because she didn't want to produce this, according to what Justin Baldoni says, but she has refused the Wayfarer party's reasonable request that the withdrawal of such claims be with prejudice. Now, Wayfarer is the production company Justin Baldoni was involved with as he did this film. Miss Lively wants to simultaneously refuse to disclose the information and documents needed to disprove that she suffered any emotional distress and or that the Wayfarer parties were the cause, and B, maintain the right to refile her IED claims at an unknown time in this or some other court after the discovery window has closed. And we'll get into what that means, but I want to stop for just a second and just ask you to think for a minute about how significant that is. Because what Blake Lively is saying is she is actually going to withdraw her claims rather than produce these records. So remember, she filed these claims with a lot of fanfare. There was a story in the New York Times. She spoke in advance to someone at the New York Times, a reporter. And now she's just going to walk away from these claims. She's just going to leave them. That is really significant. And according to Baldoni, the reason for her walking away is just not wanting to produce these therapy records. That is a pretty huge move just to avoid producing the therapy records. These aren't just any claims. These are really important claims for the kind of arguments that she can make. She, in this particular, let's go back and look at this again. I want you to think of what she's losing in terms of what she could perhaps prove. let's go to the elements over here. Remember, she has the right to prove severe emotional distress if she's pursuing intentional infliction of emotional distress. She has the right to prove that the defendant engaged in extreme and outrageous conduct. She's dropping those. To some degree, this may still be possible to prove with the other claims, but anytime you drop a claim, you lose the ability to put in some pieces of evidence that otherwise might have been important. It has to really be important for her to do that. It has to matter enough that she's willing to walk away from it. It could be, in other words, a pretty significant loss. So, why? Why would she do that? Why would she dismiss her claims? And this is where it gets really fascinating, because if those therapy notes would help her, if they were helpful to her, you would think she would want them in. She would be very excited to say, look, here are the therapy notes proving that I had a problem based on what you were doing to me and that I talked about it. But instead, she's trying to shut the door. She is abandoning 2 claims in order to do that, 2 significant claims. So are there details in the notes that she's afraid will leak? Is there something that would contradict her public narrative about the case? Or is she just afraid that in the context of this incredibly bitter battle, that it will simply be taken out of context? It could become a media circus, and she doesn't want her personal life put on blast like that. We don't know what's in the records, but we do know what she's willing to give up in order to keep these records hidden. And so that's where it gets even more strategic, because she wants to dismiss these claims without prejudice. And that is exactly what they were complaining about here. Now let's head back over to what was said. Remember what they said, that she wanted to not give them any of these therapy notes and have the right to refile these claims later. And they're saying, look, you can't do both of those. If you won't give us the information, we'll talk about whether that's true or not. But they're saying you should have to dismiss this with prejudice, meaning you can't bring these back again. You can never bring this case again. The case is over. And you have to abandon these claims entirely if what you want is to keep your therapy records private. So that's what Justin Baldoni is arguing. So this back and forth is a legal strategy moving into a PR war. Now, here is what Blake Lively says in response. Let's head over to her response, document 264. And here's what she says. She says, look, Ms. Lively agreed to the stipulated dismissal and proposed modest revisions, offered to meet and confer. That's something lawyers usually are asked to do by the judge instead of just fighting everything out. Could you please, lawyers, agree on something? And at no point during the conference did they object to or raise any concern regarding Ms. Lively's proposed revisions to the stipulation. Essentially, what they argue in this is, we were writing you all weekend. We wrote you on Friday. We wrote you on Saturday. We wrote you on Sunday. We were doing all this back and forth. We even met in person on Monday for this conference, or in person Zoom. I don't know how they met exactly, but we met. And at no point did you say you had a problem with us asking that this be dismissed without prejudice, meaning we could refile the claims. So, why are you filing this with the court? Why are you complaining that we want to file it without prejudice? You never even told us that was a problem for you. And so the reason that Blake Lively is saying that is, she's saying, once we dismiss this case, you don't have any right to my therapy notes. The only reason you have a right to my therapy notes is these 2 claims, the intentional and the negligent infliction of emotional distress. That's it. That's the only reason you have them. Here, we'll read what she says right here. She says, this motion seeks to improperly compel documents that the Wayfarer parties lack a legal basis to obtain, and seeks no relief at all as to the stipulation. Because the Wayfarer parties concede that Ms. Lively has agreed to dismiss the 10th and 11th causes of action to which such discovery is solely directed, and they have agreed to the dismissal and proposed a joint stipulation to that effect, the motion does not legitimately seek any form of relief, is irrelevant to any motion currently pending before the court. What Blake Lively is arguing here is the only reason you ever even had a right to get the therapy notes was because you were trying to defend yourself against this infliction of emotional distress claim. If we get rid of that, you have to admit you have no right to get these records. So it doesn't matter whether it's dismissed with or without prejudice. The bottom line is it's going to be out of the case and you don't have a right to see these notes anymore. So your motion doesn't make sense. You can't just say, I still want these documents, even though the claims are being dismissed. You can't say that. You have to accept that we're going to dismiss it. So her lawyers are arguing this is really the defense trying to harass her and to embarrass her publicly. She even asked for sanctions against Baldoni's team. Let's go up here. The motion was filed for a single audience, the media. There's nothing for this court to compare. As the Wayfarer parties make abundantly clear in their motion, Ms. Lively voluntarily agreed to withdraw her infliction of emotional distress claims on Friday, May 30th. Ms. Lively did so in good faith to streamline the dispute in the ordinary litigation process, given the damages she otherwise anticipates recovering. So she's not agreeing that the reason she's doing it is to avoid producing the document. She's saying it's for the bigger reason of just trying to streamline the litigation. It's not just related to that. And they say, but they, meaning Justin Baldoni's side, has been desperately searching for an angle to make a show out of Miss Lively's decision to streamline her case. They say, here's what they want. They say, we've agreed to dismiss the 10th and 11th causes of action. So you need to exercise your inherent authority under the rules to dismiss them without prejudice, under Rule 15, to dismiss them without prejudice. So let me pull out of that so we can talk a little bit more. So Blake Lively is trying to frame this as just a media stunt by the defense, that this is something designed to create headlines, to make it look like Blake Lively has something to hide in these therapy notes. It definitely can work in both directions because the more she fights to keep these secret, the more she's willing to give up for that, and 2 claims is a big giveaway, then the more people will wonder what is in these therapy notes, what is making them so problematic for her to produce. So what's going to come next? Well, the judge has to make a decision on this. Does Blake get to walk away from her claims without showing the records in federal court? You do have to, at once the complaint has been answered, which is the case here, then Blake has to get permission to dismiss the claims. So does Justin Baldoni's team have a right to these notes? Even if she will, first, if these claims are out, I don't think they do have a right to these notes, and they would even admit this. The question really is can the court force her to dismiss this with prejudice, meaning she can never bring it again? Or can the judge, and in which case, maybe she would just decide to go ahead and keep prosecuting the case. Normally, judges will allow a plaintiff to dismiss claims, to drop claims. And if the judge is going to approve it, just typically they do that. And why? It's pretty obvious, right? Because they don't want to have to deal with more claims and more cases than they have to. It's just more work for them. So they would definitely rather these claims get dismissed if nobody really wants to pursue them. Why should the judge spend time on them? And I don't think the judge is very likely to say, well, you get discovery anyway, and I'm going to force them to keep these claims in that both of you think should be gone. But there are 2 huge takeaways here, I think. The first is that the legal strategy here is being used as leverage. Both sides are trying to use the legal issues to further the case. And it's less, like I say, about what's in the records and more about who is controlling the story. Now, Baldoni's team is putting pressure on Blake to either prove her claims or to walk away entirely on these intentional infliction of emotional distress, negligent infliction claims. And Blake is wanting to walk away only on her own terms. So in a high-profile case like this, absolutely everything that happens in court is also happening in the court of public opinion. So if Blake Lively drops her claims, the press covers that. And if she keeps them, the records she knows might become leaked, might end up leaked, or might become public at a hearing or at the trial, just as part of the regular course. Either way, she has something to lose. She's trying to minimize the damage, but the very act of doing that is kind of its own damage control, its own kind of damage. So, bottom line, the Blake Lively sued for emotional distress. The defense asked to see proof. She said no. She's willing to back away from 2 claims, according to what Justin Baldoni says, just to protect her privacy in those therapy notes, which leads to a bunch of questions. This was 100% predictable in advance. When she filed those claims, she put her mental health at issue. So why did she file these claims if she had something to hide? Do you think she's hiding something? Or is this just what a celebrity would do, knowing the media might twist it, knowing the public might see it a way that's damaging to her? Do you think it's just natural? Let me know what you think in the comments. Also, if you would like a deep dive into Ryan Reynolds' claim for sanctions against some of the defendants, not including directly Justin Baldoni, let me know about that. He said some of these defendants have been inappropriate and the court ought to sanction them. So let me know if you want more about this particular case. All right, so we'll take a few questions. I want to keep this one pretty short, so we won't take too many. I need to say thank you to Michael Lalonde. I appreciate the super chat. And also, Lisa, thank you for gifting 5 Lawyerly memberships. I appreciate that very much. All right, so if you are new to the channel, here's how we do questions at the end. We ask that you would put question marks at the beginning because it's a lot easier for me to spot in the chat if I see the question marks at the beginning. Oh, I see Annie saying she wants the Ryan Reynolds stuff. Beth has a question. If the claims are dismissed without prejudice, should Blake's therapist be warned to maintain their notes and not destroy them in the normal course of business so that they don't disappear? Really interesting question, Beth. So one of the things that probably the defendant could easily do is say to Blake Lively, now you as the patient have ownership of these documents, technically ownership of these documents. You need to put your providers on alert that they should save these records and preserve them in case you bring another suit. But honestly, even without doing that, in a lot of jurisdictions, the burden would already be on Blake Lively to do that if she knows right now that she's going to bring a suit like that, if she knows that that's going to happen. That's a great question because documents getting gone is a big problem. All right, let me see. Catherine asked me, do you think they are getting closer to a settlement? Catherine, I would be stunned if they're getting closer to a settlement. I see no way that that's happening this early in the game. And I have been a mediator for a number of years now. So what I do as a mediator, my task is to get the parties who are headed toward trial to settle their case, to resolve it before trial. And I can tell you this, it is possible to settle a case early, but it is unusual. Normally, there's just something about the pressure of knowing that things are really amping up. Both sides know exactly what the lay of the land is. They know what the case will be about. And it's then that the case can settle, not earlier than that. So a lot of times there's just everything gets put on hold while everybody litigates and fights over the case and fights over the discovery. Then you get really near trial and then everybody's ready to settle. They know what the case is about and they're just in the mind frame where they can do that. So that it would surprise me if they're ready yet. I think it'll be quite some time. KD asks, how does this affect her other causes of action and sexual harassment claims? So it would not affect her other causes of action directly. Those would still be pending. She would only dismiss these 2 claims. Everything else would still remain there. but some of the discovery that might have been useful but not directly related to that, she might not be able to ask for it. She might not have to provide it, like her therapy notes. Obviously, both parties seem to think the therapy notes don't fit under any of the other claims. So that means she's also missing something, which is an ability to prove some of that emotional, psychological toll on her of what she claims happened to her. Queen B asking, why does the judge make quit denial motions on some things, but the motions to dismiss take a while? So some motions are just easier for the judge to decide, and some the judge is going to have to write more. A motion to dismiss is a much more significant motion. Also, like a motion for summary judgment. Those are big motions that would get rid of entire segments of the case or the entire case. And so the judge really has to be careful and take time on those. They usually involve a lot more evidence, or the summary judgment would, and it involves looking at the complaint and what the elements of it are. So it just takes more time than a quick motion that's just, what about this particular issue? What about this particular fight we're having over this one discovery issue? So that's why those would typically be a little faster. It does depend on the judge, though. Some judges are quick on everything, and some judges are slow on absolutely everything, even the little motions. JKB Striving asks, Blake mentions emotional distress and many other causes of action than just 10 and 11. Are those complaints impacted? So great question. I can't recall that directly. I'll have to look at that, JKB, to see what exactly she claimed. I think if she is claiming as an element emotional distress, then Justin Baldoni's team will continue to press on the issue that she is going to need to produce those records, those therapy notes, if she's going to continue with the claim. But I can't say for sure. I don't remember the exact details on those others. Freddie's cat, do you think Blake's lawyers made a mistake or misjudged the situation when they filed the claims? Yes. Yes, I do. I think that, and I don't know if they even conceivably could have seen what was coming, but certainly they did not get what was coming. I don't think they had any clue how the public was about to react to this, or the firestorm they were going to be headed out to in social media and in the public. And it's been extraordinary. It's affected Blake. It's affected Ryan Reynolds, her husband, who a big A-list actor, world renowned, and it's been huge. So yeah, I think that I don't think they could possibly have realized what it was, and I do not think they realized what was about to happen. These are great questions. I appreciate your questions very much. I'm looking for the question marks at the beginning, so I can find them a little more easily. I'll take a look at that, JKB. I see your question there. Okay. What did you think? I don't have any opinion on that yet, Catherine. Thank you for your question. And I am willing to cover this case more if people are interested. If you would let me know that in the comments, it'll really help me as I'm kind of making decisions. My goodness, look at that. Mama Pinks has been a member for 15 months. That's awesome. Thank you, Lee, for a nice, relaxing evening. We have been covering the Karen Reed case. Mama Pinks and Marlon are our two mods, and it has been brutal. I don't know I've ever seen a more vitriolic case with people fighting and just the comments. So it is a great relief to have a little bit calmer, more measured approach. And so I really appreciate what Marlon and Mama Pinks have been doing and what they do all the time for the channel. So thank you, and glad you've been a member for 15 months, Mama Pinks. Nicole, if she drops these charges but proceeds with others, could medical therapy records be referenced at all in court? Maybe. Here's what I would anticipate. Just as JKB, did I get that right, mentioned, here's what I would expect. Anywhere and everywhere that the defense believes that they might have a reason to get those therapy notes, they now know this is a hot button issue for Blake Lively. They're going to ask for them. They're going to push for them. They're going to look for ways to make those relevant. And there may be other claims. It may not be possible for Blake Lively to dismiss them all. So we'll see whether or not she's successful in that. But that I would expect to have a lot more fights, especially if Blake Lively dismisses this well, she already wants to dismiss this. And of course, it is possible that Blake decided she really couldn't win this. She didn't really have the evidence to prove such a high standard as this one. So that's possible. But the defense is convinced in telling the public that it's because she wants to hide therapy notes. So you've now seen the motions. You know what both sides are arguing. All right. Angelique asking me, could Blake back out of this, or is it too late? Here's the problem for Blake Lively. She can't just dismiss her claims and it goes away, because there are counterclaims against her. It's not just her claims against Justin Baldoni. Justin Baldoni has also filed claims against her. And so even if Justin Baldoni's side agreed, yeah, you can get rid of everything, even if the court said, yeah, it's okay with me if you dismiss it, the case would still be going. So she definitely will not dismiss all of her claims. She needs those in there to have sort of the battle where she has something she can win and the Baldoni side has something it can win. And unless there's that, they have no hope of settling this case, which they probably will do at the last minute based on how lawyers do. It's called settling on the courthouse steps, and it is a thing. Lawyers often, they just can't get it done earlier than that. And often I've heard judges tell juries as they're sitting there and the lawyers are settling the case while the jury panel is about to be questioned for voir dire and they're about to be picked. And the judge will say, if you weren't here, they couldn't have settled. And it is 100% true, even though it sounds crazy. So, well, thank you all for being here. Catherine saying a member for 12 months. Thank you, Catherine. I enjoyed a bit of a break from Karen Reed. Me too. Me too. I enjoyed a little bit of a break. I will tell you what, that is a tough case with a lot of emotions and a lot of strong feelings on either side. And so it's fun to analyze something a little different. All right. Well, thank you for watching. Be sure to let me know if you really want me to cover this case so that I'll get the input from you, and I will look to see you. We'll be going live again tomorrow night at 7 p.m. Eastern, and I will look forward to seeing you then. There's that. There we go.